Hello, welcome all. Let us continue with our series of discussions with regard to the important topics in polity for Prelims 2023. So, this would be the last class in our series of discussions. We have already discussed 9 classes. We have discussed the important topics. Today in the last class, we would be discussing about some of the miscellaneous topics which may be relevant to the examination from polity. If you look into the previous classes, we have touched upon the most important topics like the fundamental rights, preamble, directive principles of state policy. We also touched upon the executives, legislature, and then we also touched upon the center-state relationship, judiciary, and then also the local bodies. And in the last class, we have been discussing about the constitutional bodies. If you see, 80 to 85% of the questions is going to come from these areas. And in order to not to miss out on certain miscellaneous topics, we would be covering some of the important topics from the miscellaneous topics in this particular class. So, we have touched upon both the conventional part as well as the current developments that has happened in the in the political system of India. So, in this way, the idea is to cover everything in this series of lecture. So, let us directly get into the first question for today. So, come to the first question. So, the first question is with regard to the rights of persons with disabilities in our country. Now, this topic is very, very important because it has been in news for a number of reasons. Many petitions has been filed in the Supreme Court, and it has been brought to the notice of the Supreme Court that the rights of the persons with disabilities has not been recognized, especially by the government authorities, or the government authorities has not been very sensitive to the rights of these people. Now, in order to understand this particular topic, let us try to solve this particular question. But before we get into the question, it is also very important for us to understand certain basics of this particular law. Now, recognizing the rights of persons with disabilities, the Persons with Disabilities Act was passed by the Parliament in the year 1995. And what was the requirement for the Parliament to make this particular law? Parliament wanted to make this particular law in order to fulfill its commitments with regard to the rights of persons with disabilities. There are certain constitutional commitments to protect these people, to provide equal opportunities. And also India is a party to Convention on United Nations Convention on the Rights of Persons with Disabilities. Rights of persons with disabilities. In order to protect these rights and also to honor the commitments of an international convention, the Parliament has made this particular law. But however, the Parliament felt that this particular law is not comprehensive enough, and hence they come out with the recent legislation, that is the Rights of Persons with Disabilities Act in the year 2016. In 2016, the previous version of the law was amended and they came out with a new law, that is the Right of Persons with Disabilities Act. Now, before I get into this particular act, because the act has modified the previous version of the law, and before I get into some of the important provisions of the law, look into this particular law, the rights of persons with disabilities. In fact, disability is an item in the state list. Now, can the Parliament make a law on an item in the state list? That is very questionable. But yes, you will have to understand Article 253 of the Constitution, which I have already discussed. Article 253 of the Constitution empowers the Parliament to make a law on any item in the state list if they have to honor an international commitment, or if they have to honor any convention to which India is a party, and they don't even have to take the consent of the states. Okay, consent of the states. So, Article 253 empowered the Parliament to make a law, and thereby they enacted this Rights of Persons with Disabilities Act. So, overall I can say this Rights of Persons with Disabilities Act is nothing but it is a statutory manifestation of a constitutional obligation that India has, or the constitutional obligation that the state has to provide for the people with disabilities, because the Constitution provides for equal opportunities. So, the very idea of this Rights of Persons with Disabilities is to provide equal opportunities for the people with the disabilities. So, what are the important provisions of this particular law? In fact, if you see the Rights of Persons with Disabilities Act 2016, it has increased the number of disabilities or people with disabilities who can get the benefit under this particular law. So, in the previous version of the law, there were only 7 categories of people. Now, under the rights of persons with disabilities, it has been increased to 21. In fact, the acid attack victims and people with certain types of blood disorders like the sickle cell anemia, hemophilia, all these categories of people were also brought within the category of disabled people, and they can also get the special rights. Not only this, in addition to this, the central government can make notifications. The central government can come out with certain subordinate legislations and they can increase the list. If they want to increase the list, they can increase the list in the future. So, this power is given to the central government. 3. The Act also deals with taking care of the number of needs of the people with disabilities, especially their accessibility to various government buildings and institutions. So, the Act mandates the appropriate authority to take care of the providing facilities and building up infrastructure like the special ramps in hospitals, schools and in public places for these people with disabilities, so that they do not undergo any inconvenience when they have to access these infrastructure. And then the Act also mandates reservation for the people with benchmark disabilities. So, people with benchmark disabilities are those people who are with higher level of disability, which is defined under the Act. So, they are eligible to get reservation in educational institutions, they are eligible to get reservation in public employment, they are eligible to get reservation in the lands that is allocated to them, and they are also eligible to get certain other benefits in the government schemes and all those things. So, this is all taken care under this particular Act. The Act also mandates the penalizing of the people who are not respecting the rights of the persons with disabilities. And in order to fast track all these cases, the Act also provides for a special court. So, this is a very comprehensive law in order to give effect to the constitutional commitments and to provide equal opportunities to the persons with disabilities. So, with this information, let us try to get into the question. Come to the question. Consider the following statements regarding the Rights of Persons with Disabilities Act 2016, which is seen sometimes in the news recently. First statement: the new Act replaced the Persons with Disabilities Act 1995 and also covers more disabilities than the previous version of the law. So, this we have seen. So, in the previous version of the law, there were 7 categories of persons were considered. Now, around 21 categories of people with disabilities are included under this particular law. Not only this list can be expanded by the central government through a subordinate legislation. Statement 2. The Act was enacted to give effect to India's commitment to United Nations Convention on the Rights of Persons with Disabilities. So, this is very much true. And in fact, the Parliament has made use of Article 253 of the Constitution. Although this item in the state list, still the Parliament is empowered to make this particular law. Statement 3. Although disability is an item in the state list, the Parliament can enact a legislation in order to give effect to its international commitment as a party to Convention on Disabilities. So, protect the rights of persons with disabilities. So, this particular statement is also true. Which of the statements given above are correct? So, the right answer would be all of the above. So, this particular topic is very, very relevant. Few years back, a question on disability on this particular Act has also been asked in the mains examination. But otherwise also, it is very important this year also, because there is a lot of cases in the courts. And also, as a person who is preparing for the civil service, as a candidate, we will have to be very sensitive about the rights of these people, persons with disabilities. Okay. So, this is a very, very important topic in my opinion. Now, let us go to the second question for discussion. The second question for discussion is related to the Right to Information Act. This Act is a very, very important legislation. And in fact, this Right to Information Act has been recognized as among the few categories of laws which has been so influential in shaping India in the last 75 years. So, in this particular context, it was also reported in the news for a number of reasons. So, let us try to understand some of the basic provisions. And also, this particular act has been amended a few years back, and some of the provisions of the Right to Information Act has been changed. So, in this context, let us try to understand what is important with regard to the Right to Information Act. So, before I get into the question, the Right to Information Act, which is popularly called as the RTI Act, was enacted by the Parliament in the year 2005. If you look into the objectives and reasons of this Right to Information Act, the Right to Information Act was enacted to make the governance in India more transparent and accountable, and also India's commitment to give access to the citizens with regard to the information of the government. So, what is the objective behind which this particular law was enacted? In order to give the citizens access to public information, that is the governmental information, which has been recognized as a right by a number of courts even before this particular legislation was enacted, and also to promote more transparency and to make the system more accountable and also to prevent corruption. So, all these has been the objectives behind this Right to Information Act. The Act mandates that each and every government department should have a public information officer who is popularly called as the PIO, and this PIO would be the nodal authority to disseminate information based on the request that the citizens might seek to get the information about the government department. So, this PIO has to give the information within a period of 30 days. 30 days is the time limit, or if the information is related to right to life and liberty of an individual, within 48 hours. If the PIO is not giving the information, then the individual who has filed this RTI petition seeking the information can go to his appellate authority, the appellate authority of the PIO to his immediate supervisor, would be his immediate supervisor, and an appeal can be made to his immediate supervisor. If he is also not responding, then the Act also provides for establishment of a Central Information Commission at the central level and the State Information Commission at the state level. So, if the information is pertaining to the central government department, further appeal can go to the Central Information Commission. If the information is related to the state government, then it can go to the State Information Commission. A further appeal can lie in the High Court concerned. Further appeal can go to the Supreme Court. So, this is what is mandated under this particular Act. The Act also recognizes that not in every case that the citizens or the individuals have to seek the information. The Act also mandates that there should be a voluntary disclosure of information on the part of the government itself. So, which is dealt under Section 4 of the Right to Information Act 2005. Not only the voluntary disclosure, but the citizens can also seek information. But however, the Act also balances the need to maintain the confidentiality in certain information, which is especially related to the national security concerns and issues. So, under Section 8 of the Representation of People Act, certain information can be exempted. So, there are certain exemptions. Not all information are available. So, that is provided under Section 8 of the Representation of People Act. The Section 8 of the Right to Information Act. So, all these basic information are very, very important. Now, let us get into the question and then try to understand as to what kind of changes have happened in the recent past. The Right to Information Act was amended in the year 2019. And today the law is amended. In fact, during the debates in the parliament when an amendment bill was introduced, in fact, some of the members of the opposition has called this as a right to elimination bill. It is not a right to information act anymore. It is a right to elimination bill. Elimination of the information from the government. But however, this act has been passed. So, let us try to understand the provisions of the amendment that has happened. So, come to the first statement. As per the amended version of the Act, the term of the Central Information Commissioners and the State Information Commissioners would be 5 years or until they attain the age of 65 years. In fact, this was the provision of the Act before the law was amended. When the law was amended in the year 2019, they have changed this particular thing and they said now the term is not fixed. Rather, the term can be determined by the central government. So, that is why the opposition parties have said that if the term can be unilaterally changed by the central government time to time and if the power is given to the central government, it clearly infringes upon the independence of this particular body and this is not right for democracy. So, today the term is not fixed, but who is going to determine the term, and it may case to case vary also. On case to case basis it can vary also. So, who is going to determine the term? The term is going to be determined by the central government. So, this particular statement is wrong. Come to statement number 2. The salary of the Chief Information Commissioner and the Information Commissioners at the central level will be equivalent to that of the Chief Election Commissioner and that of the Election Commissioners respectively. This was a provision of the original law. The original law, the Right to Information Act 2005 said that the salary of the Central Information Commissioner, that is a Chief Information Commissioner, will be that of the Chief Election Commissioner and the Information Commissioners will be equal to that of the Election Commissioners. Similarly, at the state level, the law said the salary of the state information commissioner would be that of the state election commissioner, and that of the other information commissioners at the state level will be equivalent to that of the chief secretary of the concerned state. But now this has been amended, and now the salary will be determined by the central government, and the other service conditions can also be determined by the central government. Okay, so this particular statement is also wrong. So choose a correct option from the quotes given below. So the right answer would be neither one nor two. So again, this Right to Information Act is very, very important. As a citizen of this particular country, it is very important that we are aware of how to seek information from the government. Okay, so this is the basics of the Right to Information Act. Let us move to the next question. The next question is related to the schedules in the Constitution. Schedules are very, very important for your examination. You can see in the last 10 years, at least in the 4-5 years, there's a question that is coming from schedule. Very simple questions are being asked from these schedules. So it is very important for us to understand about these schedules as well. Just remember the factual information of the schedules. That would be more than sufficient for the preliminary examination. Also, it is not just a conventional topic. It has been there in the current affairs for a number of reasons. So, for example, yesterday there was a news on the 9th schedule of the Constitution. The Jharkhand has already passed a bill, and they have requested the Parliament to amend the Constitution and to place that particular law into the 9th schedule of the Constitution, because the Jharkhand government is now trying to increase the reservation beyond the 50%, and to get the judicial immunity, they wanted this law to be placed inside the 9th schedule, which is only in the hands of the Parliament to amend the Constitution and to place the law inside the 9th schedule. And last year there was a news with regard to Leh Ladakh, which is requesting the 6th schedule status to be given to the Union Territory of Ladakh. So for which there is a need to amend the Constitution and to place that in the 6th schedule. So for number of reasons, these schedules are there in the news, and there's a lot of anti-defection law is being applied. The lot of members of the Parliament and the members of state legislature getting disqualified. So in this context, the 10th schedule of the Constitution is also very relevant. So in this context, let us try to solve this particular question. But before I get into the question, so this question is dealing with the anti-defection law. So it is important that you know that this anti-defection was not a ground for disqualification in the original Constitution. The original Constitution never had this. Probably the Constituent Assembly never thought that such a thing would happen in the future. But however, after the Constitution came into force, especially after the mid-1960s and subsequently, the defection has increased to a lot. So defection basically means a person who has got elected from one political party after winning the elections from a party ticket of a particular party, and then he switches his allegiance to another party. He changes his loyalty to another party, supports another party. Then this may lead to what is called as, so this is basically what is called as defection. So later the Parliament thought that the defectors has to be punished, and what should be the punishment for a political defection? That they shall be disqualified to be a member of Parliament or a member of state legislature. And this provision was brought into the Constitution for the first time in the year 1985. 1985 by the 52nd Constitutional Amendment Act under the leadership of Prime Minister Rajiv Gandhi. So they amended Article 102 and Article 191 of the Constitution to make defection as a ground for disqualification for both the members of Parliament under Article 102 and the members of state legislature under Article 191. So the presiding officers, so this is very important. In other cases, it would be the president and the governors respectively. But in case of defection, the presiding officers would be the disqualifying authority. Try to remember this. And subsequently, the act was once again amended by the 91st Constitutional Amendment Act in the year 2003, and they made a subsequent change to the anti-defection law. So there was an exception under the anti-defection law, what would not be considered to be defection even if there is a split in the party. So initially under the 52nd Constitutional Amendment Act, it was 1/3 split. And this 1/3 split was rather easy and it was happening, and in order to avoid this, the 1/3 split was replaced by 2/3 merger. So now it is a little difficult for a faction to move out of the party and still be not subject to the anti-defection law. So these are the basics you will have to understand. And however, what would be considered to be defection? So if you look into the anti-defection law, which is explained in the 10th schedule of the Constitution, the 10th schedule of the Constitution says that there are 4 categories under which people can be disqualified on the grounds of defection. Any person who was elected from a particular party ticket who engages in any anti-party activities, or if he is acting contrary or voting contrary to the directions that is given by the party, that is one ground. And then the second ground is that if an independent member gets elected to the house and the independent member is joining any political party during the term of the house, then he is liable to be disqualified. And then any nominated member, this is the last category, any nominated member, and if the nominated member joins any political party after 6 months after his nomination, then also he is liable to be disqualified on the grounds of defection. So these are all as to what constitutes defection as per the 10th schedule of the Constitution. So not only we will discuss about the 10th schedule, the other schedules are also important. I'll just come back to that particular area. But before that, which of the following schedules deals with the anti-defection in the Constitution, which is a ground for disqualification of the members of Parliament and state legislature, that is 10th schedule. But otherwise, all these schedules in the Constitution is also very, very important. So there are 12 schedules in the Constitution. The original Constitution had 8 schedules, so this is also very important. Originally there were only 8 schedules, but today we have 12 schedules in the Constitution. So try to remember all these schedules as well. So what is the first schedule of the Constitution? The first schedule of the Constitution talks about the name and the territories of the Union. And the second schedule talks about the salary and the allowances of certain members. What about the third schedule? The third schedule talks about the oath that is to be administered to certain constitutional and other dignitaries. Schedule 4 talks about what? The allocation of seats in the Rajya Sabha. Schedule 5 and Schedule 6 we have already seen, which was also in the newspaper. Schedule 5 talks about the scheduled areas in all the country except in the state of Assam, Meghalaya, Tripura and Mizoram, whereas the Schedule 6 talks about the tribal areas in the states specifically of Assam, Meghalaya, Tripura and Mizoram, and that is the tribal areas in these states. And what about Schedule 7? Schedule 7 talks about the distribution of legislative items, that is the concurrent list, the union list and the state list. So all these things are mentioned in the Schedule 7 of the Constitution. And what is Schedule 8? Schedule 8 is about certain languages. There are 22 languages. The most important languages are mentioned in the Schedule 8 of the Constitution. So these were the schedules in the original Constitution. The Schedule 9 was inserted by the first Constitutional Amendment Act. So first Constitutional Amendment Act through which Schedule 9 was inserted in the year 1951, and this provides judicial immunity to certain laws which is placed inside the 9th schedule. But however, today the position of 9th schedule is not the same. Today the laws which is placed inside the 9th schedule can be judicially reviewed on the ground that it violates the fundamental rights that constitute part of the basic structure, which we already discussed. Schedule 10, it talks about the anti-defection law. Just now we have discussed this. Inserted in the year 1985. Schedule 11 and Schedule 12, they both were inserted by the 73rd and the 74th Constitutional Amendment Act, both in the year 1992. And what do they deal with? They deal with the functional items both in case of Panchayat and municipalities. So what are the areas on which the Panchayat and the municipalities can be empowered by the concerned state legislature? So there are 18 functional items in case of the Panchayats. Okay, so it talks about the functional items. Okay, so this is the basic understanding that you should have with regard to the these schedules, and schedules are very, very important for your examination. So now let us move to the next question. Again, a very important question in my opinion, which is related to the public interest litigation. So what is this public interest litigation and why it is there in the news? Every day a number of public interest litigation is filed, and every now and then you can see most prominent judgments of the Supreme Court is now brought to the notice of the courts in the form of a public interest litigation. So what exactly is this public interest litigation? Now, PIL as a concept has emerged in the United States of America, and from United States of America, it has moved to India. And the first most prominent PIL in our country was considered to be the Husainara Khatun versus the state of Bihar case, which happened in the year 1979. Although this is not the first case, Husainara Khatun versus state of Bihar case in the year 1979, but it was considered to be the first most prominent PIL, bringing to the notice of the Supreme Court the plight of under trials in India. Now, in this context, you'll have to understand as to what is a PIL. Now, before that, the constitution as well as the legal provisions in our country allows an individual the right to litigate. That means, whenever an individual feels that his right is violated, he can bring it to the notice of the court. He has the right to litigate. And basically, you'll have to understand before we proceed further a concept which is called as locus standi. So, on the one hand, we say that the right to litigate is the right of an individual, but who can bring it to the notice of the court? Is it the affected individual or somebody else on behalf of the affected individual? So, traditionally, the courts recognized only the principle of locus standi. That means somebody, when they file a case in the court is going to ask that what is your standing in this particular case. If you have a standing, then that means you have a locus standi. So, traditionally, only a person who has a standing, who is affected because of a particular case, has a right to bring it to the notice of the court. But however, over a period of time, the Supreme Court recognized that not every individual in our country may have the resources to or the legal knowledge to take it up to the court and to fight and to defend his rights and to seek the remedy. So that is when the court recognized, okay, now it is not only the affected individual should be allowed to fight the case or to file the petition, any public spirited individual or any social action group can also file this particular petition. So this is how the PIL was recognized in our country. One such prominent case was the Husainara Khatun versus state of Bihar case, very influential case, which has also added one more fundamental right under Article 21 of the Constitution, is the right to speedy justice. But however, most importantly, there was another case which is the SP Gupta versus the Union of India case, the year 1982, that has made PIL or that has provided a standardization for the PIL in our country as to, or it has given standard guidelines as to how the PIL can be filed in the courts. And the SP Gupta versus Union of India case said, so any public spirited individual or any social action group or any public spirited individual can file a public interest litigation. A public spirited individual is someone who has a bona fide intention. In good faith, he is bringing it to the notice of the court that the violation of rights of the other people, although he is not directly affected because of this particular case. A social action group is a group which is which is working for a positive change in the society. So, for example, the NGOs may be coming under this particular category. So, they all can file public interest litigation under the writ jurisdiction of the Supreme Court and High Court, that is both under Article 32 and Article 226 of the Constitution. So, in case of violation of fundamental rights, not necessarily the affected individual have to bring it to the notice of the court. If the affected individuals are not able to do that, it can also be filed in the form of a public interest litigation. So, that's the basic understanding that you should have. Subsequent to the SP Gupta versus Union of India case, then there is no stopping to the PIL in our country. A lot of PIL is filed, and in fact, it has become a very important tool to protect the rights of the underprivileged in our country. Look into the number of look into the number of cases related to environment, look into the number of cases related to the poor sections of the society. So many of these things has been brought in the form of a PIL. So with this information, let us try to get into this particular question. Consider the following statements regarding the position of public interest litigation in India. Statement 1. The principle of locus standi strictly applies in case of the public interest litigation. So, does the principle of locus standi strictly applies? The principle of locus standi is liberalized. It does not strictly apply in case of a public interest litigation. So, this particular statement is wrong. Statement 2. The public interest litigation can be used to challenge the violation of fundamental rights by any social action group or public spirited individuals, although they may not directly have an interest in the case. So, this is very much true. So, this is what has been legalized by the Supreme Court in the SP Gupta versus the Union of India case. statement number 3. The term public interest litigation is well defined in the constitution. No, it is nowhere defined in the constitution. So it is just an interpretation of the courts. But however, please understand, the public interest litigation has become a very important tool today to protect the rights of the people, as we already seen, especially the underprivileged. But it is not without any criticism. In fact, a few days back, there was an article which the Supreme Court has said now the public interest litigation has become a tool to blackmail the government or to blackmail the other individuals, especially with regard to the infrastructure development and all those things. So there is a lot of criticism that is surrounding this public interest litigation, because the critics say the public interest litigation is also used as a political interest litigation. So, or it is a personal interest litigation. So what are the other problems? It may be a personal interest litigation, or there may be a publicity aspect related to this. It is also called as a publicity interest litigation, or it is a political, for political reasons also it is filed. So there are all ways by which the public interest litigation can at times be misused. So that is definitely true. And also there is another criticism relating this public interest litigation, that the public interest litigation can be used to unnecessarily waste the time of the judiciary. So all these problems are there, and at times the judiciary also engages in what is called as judicial overreach or judicial adventurism because of this public interest litigation. Judicial adventurism or overreach. Okay, so although the criticisms remain, but public interest litigation has come a long way in addressing the violation of rights of the people. So with this, what is the correct answer? So the question is, which of the statements given above are incorrect? So the incorrect would be option 1 and 3. So the answer would be option B. Option B is the right answer. Let's move to the next question. The next question is related to the Panchayat extension to the scheduled areas, a very, very important piece of legislation. The Panchayat extension to the Scheduled Areas Act was passed in 1996, and subsequently even the UPSC examination in the last 10-15 years, it has been asked more than 2 times. So it is a very, very important topic. It can again be asked. It was reported in the newspaper for a number of reasons. In Gujarat recently, the Aam Aadmi Party, during their political rallies, they said that if they come to power, they will effectively implement this Panchayat extension to Scheduled Areas Act. And in number of other tribal areas where today the Schedule 5 of the Constitution is applied, there also the PSIR Act applies. So the chief ministers of all those states have also taken initiatives to apply this Panchayat extension to the Scheduled Areas Act. So what basically is this PSIR Act? Now please understand, the PSIR Act was passed by the Parliament in the year 1996. The idea of this PSIR Act, as the name suggests, they wanted to extend the provisions of Panchayat to the scheduled areas. To the scheduled areas. To the scheduled areas, which is covered under the Schedule 5 of the Constitution. Schedule 5 of the Constitution, that is by virtue of Article 244 Clause 1. We know that under Article 244 Clause 1, wherever there is a significant tribal populations in the country, and those parts of the country can be declared to be a scheduled area by the President. The President can declare certain areas to be a scheduled area, and today there are 10 states that are covered under this scheduled area. The only exception is the state of Assam, Meghalaya, Tripura and Mizoram will not fall under these scheduled areas. They will not fall under Assam, Meghalaya, Tripura and Mizoram will not fall under the Schedule 5, because Assam, Meghalaya, Tripura and Mizoram is protected under the Schedule 6 of the Constitution and by virtue of Article 244 Clause 2. So apart from the states of Assam, Meghalaya, Tripura and Mizoram, if there is a significant tribal population, all those areas within the state can be declared to be a scheduled area. The President has the power to expand the scheduled area, decrease the scheduled area by issuing a notification. But what is the idea behind declaring certain areas to be a scheduled area? The idea behind declaring certain areas to be a scheduled area is that once an area is declared as a scheduled area, this area will have a certain special power. The laws of the Parliament and the state legislature may not apply to these areas, and it may apply subject to the modifications that the governor may bring in. And what has happened over a period of time is, after declaring certain areas to be a scheduled area, the central government thought that we'll have to bring in the institution of panchayat to these scheduled areas. And we know that the 73rd Constitutional Amendment Act in the year 1992 has institutionalized the system of panchayats. But however, the system of panchayat, if you look into the 73rd Constitutional Amendment Act, the system of panchayat will not apply to the scheduled areas. So we'll have to bring in a different system of panchayat to the scheduled areas, almost similar to that of what is given in the constitution. But the only difference is, in case of the PESA Act, the Gram Sabha which will be established in these scheduled areas will have complete control over the social initiatives in that particular area. The Gram Sabha has been empowered far better than what it is there in the 73rd Constitutional Amendment Act. So to put it in a very simple way, for the entire country what applies except the Schedule 5 areas, for the entire country the 73rd Constitutional Amendment Act applies to bring in grassroots democracy. For the Schedule 5 areas, the Panchayat extension to the Scheduled Act 1996 applies. For the Schedule 6 area, these two things does not apply, because for the Schedule 6 area, there is a separate autonomous council which will carry out the administration and which will take care of the needs of the people. So with this information, come to the first question. The first question, the first statement. So before that, look into the question. Which of the following statements are true regarding the provisions of the Panchayat extension to the Scheduled Areas Act 1996? Statement 1. The Panchayat extension to the Scheduled Areas Act 1996 applies to the areas covered under the Schedule 5 and the Schedule 6 of the Constitution. While it applies to the Schedule 5 of the Constitution, it does not apply to the Schedule 6 of the Constitution. That is in case of Assam, Meghalaya, Tripura and Mizoram. In these areas, there is an autonomous district and there is an autonomous district council. So the autonomous district council will take care of all these things. So it does not apply to Schedule 6. So this particular statement is wrong. Statement 2. The Act empowers the Gram Sabha to have control over the minor forest produce, minor minerals, minor water resources, local markets, and approving the developmental plans in the area. So everything is true. The complete social development with regard to the areas covered under the Schedule 5 of the Constitution is given to the Gram Sabha. But unfortunately, the Gram Sabha is not performing all these functions. The people are deprived of their rights, which the Panchayat extension to Scheduled Areas Act is empowered to do. That's the biggest problem. That is very unfortunate. But however, this particular statement is true. So choose a correct answer from the codes given below. So the answer would be, the first statement is wrong, statement 2 is right. So the right answer would be option B only. Very important topic. So please be prepared on this particular area. So the next question, let us quickly move to the next question. So the next question is related to some constitutional provisions related to the public services in our country, the central services and the state services. There are 4 important articles you should remember when it comes to public services in our country, which can be asked in the examination. Although this is a miscellaneous part, but please be aware of this thing also. So the first thing is Article 309 of the Constitution. So Article 309 of the Constitution gives a power to the Parliament and the state legislature to make laws and to respectively regulate the service conditions of the people in the union and the state services. So the Parliament can make a law and they can regulate the service conditions of the people in the union government, and the state legislature can make a law and they can regulate the service conditions of the state government employees. Article 310 says that the central government employees or the public servants who are part of the union government and the state government employees shall hold office during the pleasure of, this is very important, during the pleasure of the president and the governors respectively. So that means all the union government employees will hold office during the pleasure of the president, who is the appointing authority for them, and all the state government officials shall hold office during the pleasure of the governor. And if the president or the governor is not happy with the functioning of the government employees, then they can be removed. So does it mean that the government employees can be arbitrarily removed from their positions? Because it is saying that they hold office during the pleasure of the president and the governor. So for which we'll have to see this pleasure, doctrine of pleasure has to be read along with Article 311 of the Constitution. 311 of the Constitution. That means Article 311 of the Constitution says that they have the right to represent. So if any government employee is to be removed or dismissed from his service, he or she should be given an opportunity to represent himself. That means a formal enquiry has to be conducted by the government, and in the enquiry, the individual should be given the right to represent his course of action. And once this opportunity is given, and after the formal enquiry is completed, and then the government finds that there is a mistake on the part of the government employee, then only they can be removed from the service. And then it can also be subsequently challenged in the courts. That's another matter. But it only means that the pleasure cannot be arbitrarily exercised. The pleasure is subject to the right of the person to represent. And then the other article is Article 312 of the Constitution. Article 312 of the Constitution is related to the creation of new All India Service. So presently there are 3 All India services in our country, which we already discussed. The Indian Administrative Service, Indian Police Service, and the Indian Forest Service. Recently there were a lot of discussion with regard to creating a new All India Judicial Service. So can it be created? Very well, yes, under the provisions of Article 312 of the Constitution. But however, to create a new All India Service, first of all, the Rajya Sabha has to give the approval, which we already discussed. So under Article 312 of the Constitution, the Rajya Sabha has to give an approval in the form of a resolution, which has to be passed by special majority. And in this case, the special majority would be not less than 2/3 of the members present and voting. If the Rajya Sabha gives the approval, then the parliament can enact a legislation, and then they can create a new All India Service. And this is the way that they can create a new All India Service. So all these articles become very, very important when it comes to public services in our country. So with this information, come to the question. Statement 1. Any new All India Service can be created by an act of parliament only with the approval of the majority of the state legislature. So any new All India Service can be created by an act of parliament only with approval of the majority of the state legislature. So the state legislature have no role to play. So this is just a distractor. There is no such provision in the Constitution. A new All India Service can be created by the parliament and with approval of the Rajya Sabha. So that we already seen. So this particular statement is wrong. Statement 2. Under the Constitution of India, the members of union and the state services hold office during the pleasure of the president and the governors respectively. So this is true. So they hold office during the pleasure of the president. So it doesn't mean that this power can be arbitrarily exercised. Okay. So it has to be read along with Article 311 of the Constitution, but otherwise it's a correct statement. The parliament and the state legislature may by a law regulate the service conditions of the members of the union and the state legislature respectively. So this is true by virtue of Article 310, and this is true by virtue of Article 311 of the Constitution. So which of the statements given above are correct? So the right statement would be option 2, 1, 3 only. Let us move to the next question. The next question is related to the Citizenship Act 1955, which was also considered to be one of the most significant laws in the last 75 years, and which has shaped the history of India after the commencement of the Constitution. Now look into this particular question. So which of the following ways by which a foreigner can become an Indian citizen under the Citizenship Act 1955? Now before I get into the question, we all know that the Constitution deals with citizenship. In fact, the Constitution deals with the citizenship, but the Constitution does not provide every information as to who would be the citizen of India, especially after the commencement of the Constitution. All that the Constitution says that as to who would be considered or deemed to be the citizen at the commencement on 26 January 1950, subject to certain criteria, all these people would be determined or considered to be the citizen of India, which is governed under Article 5, 6, 7 and 8. But however, the Constitution does not provide as to who would be the citizen subsequent to the commencement of the Constitution, because citizenship can be a very dynamic concept and they don't want to put everything in the Constitution itself, because it makes extremely difficult to amend the constitution in the future, and hence under Article 11 of the constitution, they have given the power to the parliament to regulate their citizenship subsequent to the commencement of the constitution. And accordingly, the parliament has enacted this particular law, that is the Citizenship Act 1955, which has been subsequently amended number of times. In 1986 it was amended, 2002 it was amended, 2015 it was amended, lastly in 2019 it was amended. So these are some of the significant amendments to this particular act. So if you look into the Citizenship Act 1955, it provides for certain categories as to how the citizenship can be acquired and also how the citizenship can be renounced. Now the question is related to how the citizenship can be acquired by a foreigner under the Citizenship Act 1955. So if you look into the Citizenship Act 1955, it talks about 5 categories as to how the citizenship can be acquired. So what are the categories that especially the citizenship can be acquired? It talks about citizenship by birth, citizenship by descent, citizenship by registration, citizenship by naturalization, and citizenship by incorporation of territory. So now under this, what are the categories that is applicable to the foreigners especially? Now what is citizenship by birth? Now citizenship by birth today, if you look into the provisions of the act today, citizenship by birth is not for a foreigner, but any child which is born in India, but within the territory of India, but one of the parents should be an Indian citizen. So one parent should be an Indian citizen and other is not an illegal migrant. So it is not completely to a foreigner, but it is a child which is born in the territory of India to an Indian parent and other is not an illegal migrant. So citizenship by descent, so it is not for a foreigner. Citizenship by descent. Citizenship by descent is based on the concept of a person acquiring the Indian citizenship because by blood he is related to an Indian citizen. That is citizenship by descent. So in this case, a child which is born outside the territory of India but born to an Indian parent, even if one parent is an Indian parent, that is sufficient enough. At least one parent is an Indian citizen, child born outside the territory of India, and the birth of the child has to be registered within a period of 1 year in the nearest Indian consulate. In whichever country they stay, in those countries it has to be registered. Okay, so this is the criteria. So this is also not completely for a foreigner. So this is also wrong. Citizenship by registration. So this is completely for a foreigner. So but under citizenship by registration, 3 categories of foreigners are allowed to become an Indian citizen. One who is a person of Indian origin, or one who has got an overseas citizenship of India, cardholder status, or a foreigner who marries an Indian citizen. He marry an Indian citizen. So all these categories of foreigners can become an Indian citizen subject to certain conditions which is given in the act itself. So who is a person of Indian origin? A person of Indian origin is someone that who, according to the provisions of the law, is someone who himself or his parents or grandparents were born in the territory of undivided India according to the Government of India Act 1935, or any other territory acquired by India subsequent to its independence in 1947, but presently who are having a foreign passport. Presently they are citizen of some other country. And OCI cardholder status. And OCI cardholder status is someone that a person of Indian origin or someone who was a citizen of India can become an OCI cardholder status, and anyone who is having in this OCI cardholder status can also become an Indian citizen through the process of registration, although the conditions that they have to satisfy is a little different. And any foreigner, if that foreigner marries an Indian citizen, stays in India ordinarily for a period of 7 years, and in that relationship of marriage, then he is also eligible to become an Indian citizen. So this is true. And citizenship by naturalization. So naturalization, yes, any foreigner can become an Indian citizen provided that he is not an illegal migrant. So any foreigner plus not an illegal migrant. He can become a citizen of India provided that he is ordinarily resident in India for a period of 12 years and subject to satisfying other condition which is given in the Schedule 3 of the Act. So they can also become the Indian citizen. But there is little bit of controversy today with regard to this citizenship by naturalization, because the original Act says that he or she should not be an illegal migrant, the foreigner, to become an Indian citizen. But the Citizenship Amendment Act 2019, CAA Citizenship Amendment Act 2019 says that even an illegal migrant can become an Indian citizen through the process of naturalization. But this illegal migrant should have entered only from 3 countries as an illegal migrant: Pakistan, Afghanistan and Bangladesh. If any illegal migrant has entered into India from Pakistan, Afghanistan and Bangladesh, and if they have entered before 31st December 2014, but however these illegal migrants has to belong to 6 communities: Hindus, Christians, Sikhs, Buddhists, Jains and Parsis. So any illegal migrant belonging to these 6 communities, belonging to these 3 countries, if they have entered into India before 31st December 2014, even if they are an illegal migrant, still they would be eligible to become an Indian citizen. So the act is very controversial, which is even now pending in the Supreme Court. The matter is sub judice, but anyways, the Supreme Court has allowed to implement this particular law until they decide upon this particular matter. So this is something that the current development that has happened with regard to this particular provision. And then the last category is citizenship by incorporation of territory. So yes, naturalization is also a ground by which a foreigner can become an Indian citizen. Citizenship by incorporation of territory. If tomorrow India acquires a new territory from some other country, what will happen to the subjects in those acquired territory? Can they become an Indian citizen? Of course, yes, they can become an Indian citizen. So for example, in 2015, by the 100 Constitutional Amendment Act, India has exchanged certain enclaves with Bangladesh. Certain enclaves of Bangladesh have become Indian territory. Certain enclaves of India, which is inside the Bangladesh territory, has been given to Bangladesh. So what is the status of those people living in these enclaves? The status of these people living in these enclaves has been already given the Indian citizenship. The concerned authority under the Ministry of Home Affairs, because the Ministry of Home Affairs is the concerned authority for the citizenship in our country, has already issued a notification, and whoever is willing and part of these enclaves which has come to India and whoever is willing to become an Indian citizen can be granted the citizenship. Around 20,000 people has been approximately granted the citizenship under the incorporation of territory provision. Okay, so this is also true. So which of the statements given is are correct? So choose the correct answer from the codes given below. So except for statement 1 and 2, the other things are right. So the answer would be option 3, 4 and 5 only. So let us move to the next topic, and before that, this is a very important topic. So this is a miscellaneous area. If you see the last 10 years, I think only once there was a question from citizenship, but you never know, questions can be asked. So you should be prepared for it. Now let us move to the next topic, that is on the basic structure. The lot of questions being asked with regard to the basic structure in any form, and last year if you see there were few articles also with regard to the doctrine of basic structure. So what exactly is this doctrine of basic structure? Is there a mention of this basic structure doctrine in the constitution? There is no mention of this basic structure doctrine in the constitution. In fact, it is merely a judicial innovation innovated by the Keshavananda Bharati case in 1973. So what exactly is this basic structure as per the Supreme Court in the Keshavananda Bharati case? In fact, the Supreme Court has to decide as to what is the power of the parliament to amend the constitution. Is the power of the parliament to amend the constitution, is it limited or is it unlimited? The Supreme Court in the Keshavananda Bharati case made it very clear that the power of the parliament to amend the constitution is not unlimited, rather it is limited. And it is limited to what extent? It is limited to the extent that they cannot destroy the basic structure or the basic features in the constitution, because destroying them would take away the very essence and the very philosophy and the foundational values upon which the entire constitution is built. And also, as per the Supreme Court in the Keshavananda Bharati case, it was never the intention of the Constituent Assembly to give full amending powers to the parliament so that they can destroy or they can damage or they can alter any provisions of the constitution. So they relied upon a theory which is called as theory of implied limitations. So in the opinion of the Supreme Court, there are certain implied limitations upon the power of the parliament to amend the constitution, and hence they cannot destroy that. But who will decide as to what constitutes the basic structure? The Supreme Court has said that we will decide this. So the Supreme Court is the only authority in our country can decide as to what constitutes the basic structure. And time and again after the Keshavananda Bharati case, in number of cases, the Supreme Court has declared a number of provisions to be part of the basic structure. And history has given us the evidence that this doctrine has played a very important role, and many times the Supreme Court has tried to prevent the arbitrary action of a majoritarian government. If the majoritarian government, if they have the majority, then they can alter the entire constitution. But the Supreme Court has struck down few of those amendments which it found to be violative of the basic structure. Okay, so it's a very, very important question to be understood, so and a topic to be revised and to be prepared before the examination. So with this information, let us go to the question. So statement 1, the basic structure doctrine is well defined in the constitution under Article 13. No. So Article 13 does not define as to what is basic structure. In fact, Article 13 defines as to what is law, what constitutes law under Article 13 of the Constitution. Okay, and if you look into that, it is also distinguished by the Supreme Court that an ordinary law is different from a constitutional provision under Article 13 of the Constitution. So anyways, it does not define the basic structure. Statement 2, the only ground on which any constitutional amendment can be challenged is only on the grounds of violation of the basic structure. That is very much true. A constitutional amendment cannot be merely challenged on the ground that it violates the fundamental rights, as long as the fundamental right is part of the basic structure. So the only ground on which a constitutional amendment can be challenged is on the ground that it is violative of the basic structure. The basic structure can be anything which can be part of fundamental rights or outside fundamental rights. Anything that is violative of the basic structure, a constitutional amendment can be challenged. So which of the statements given above are incorrect? So the incorrect statement would be option 1 only. Very, very important topic. Please be prepared on this particular topic. Let us move to the next question, and again it is from the miscellaneous topics like citizenship. Now look into the particular question. So consider the following statements. The Constitution of India allows its citizens to possess multiple citizenship of different countries at the same time. This is not at all possible. The Constitution under Article 9 of the Constitution and as well as under the provisions of the Representation of People Act under the provisions of the Citizenship Act 1955 makes it very clear that there is only single citizenship. So this is not at all possible because the Constitution recognizes only single citizenship. Statement 2, only a person born in India can acquire the Indian citizenship. So just now we have seen under the Citizenship Act 1955, not only a person born in India can acquire the Indian citizenship, but also a foreigner who is born somewhere else in any part of the world can also acquire the Indian citizenship, especially by the process of registration, naturalization, and also through incorporation of territory. So majorly it is through registration and naturalization, but yes, incorporation of territory can also happen. So this particular statement is wrong. Only citizen of India will have the right to vote in the general election. So this is very much true by virtue of Article 326 of the Constitution. So Article 326 of the Constitution provides for adult suffrage, but Article 326 of the Constitution not only deals with this. So Article 326 of the Constitution read along with the Representation of People's Act 1950 also says that only an Indian citizen subject to certain conditions without any discrimination shall have the right to vote. So both Article 326 and the Representation of People Act 1950 is relevant to this particular statement. So only citizens of India will have the right to vote in the general election. So which of the statements given above are incorrect? So the incorrect statement would be statement 1 and 2 only. That is the right answer. Next, we are moving to the last question for today's discussion, and this would be the last question in our series of discussion related to the most important topics in polity for the prelims 2023 examination. If you see the way that this particular series has been designed is to take care of interest of the students who are preparing for the 2023 examination. It helps them a quick revision of all the conventional topics and also the current events related to these conventional topics. It covers, as I already said in the beginning of the class, it covers the most important topics from where at least 80 to 85% of the question is going to come. So once you revise your conventional notes, and then if you can watch these series of lectures, I'm very sure that 80 to 90% of the questions in your examinations will be made correctly by the students. Okay, so to get full benefit, try to watch all the lectures. Let us move to the last question for today. The question is related to an overseas citizenship of India card holder. Although doesn't require visa to visit India, but may require a prior permission or clearances to visit India in which of the following cases. Now please understand, post 2021, the Ministry of Home Affairs has issued notification and it has varied some of the rules related to the overseas citizenship of India cardholder status in our country. So before I proceed with this particular question, what is the genesis of this OCI cardholder, overseas citizenship of India cardholder? And who is this OCI cardholder? The OCI cardholder is not a citizen of India. That is very, very important that you have this understanding. Where it all started, in the year 2000, the Indian diaspora, people who were earlier part of India or who were born in India but now they are citizen of some other country, who have been helping India in various ways, economically, financially, culturally, politically, they have been doing extremely well in the other countries. So India recognizes the contribution of this community to India and for the growth of our nation. So in 2000, a special committee was appointed to look into the demands, because the Indian diaspora was asking for a dual citizenship because their country is allowing them to have a citizenship of India as well. So they made a demand to the government of India to provide them dual citizenship. A committee was constituted and the committee in fact recommended to provide dual citizenship. Subsequent to the recommendation of this particular committee, the government of India has looked into this particular matter. The government of India was not in a position to give dual citizenship because the constitution doesn't allow for a dual citizenship. But they thought that we will give something equivalent to that of dual citizenship, but not exactly the citizenship. And hence they amended the Citizenship Act in the year 2002. In 2002, the Citizenship Act was amended and they brought in a category of what is called as this overseas citizenship of India status. And any person who is a person of Indian origin, who was earlier a citizen of India, today he is a citizen of some other country, all these people, especially these diaspora community, they can apply for this overseas citizenship of India status. And once they get the status, what is the benefit that they may have? That they can enter into India without visa. So visa is not required. How long they can stay in India? They can stay in India for any length of time and they don't have to take permission from the foreign regional officer. So there is no need for taking the permission, but otherwise any foreigner who is coming to India, he has to take the permission if he is exceeding his length of stay in India for which he is permitted to stay. So these are the practical difficulties a foreigner might have in India. So these practical difficulties has been removed for the overseas citizenship of India cardholder. And third, they also said that if you want to purchase property in India, yes, you can purchase property. Subject to certain restrictions, of course, you can purchase movable, immovable properties, but you cannot purchase agricultural land, you cannot purchase farmhouses, you cannot purchase plantation property. Subject to these limitations, yes, you will have the other rights to purchase the property. But however, these relaxations will not apply to anybody who is a person of, or for anyone who is a citizen of Pakistan or Bangladesh. So except Pakistan and Bangladesh, so others can enjoy these benefits. So initially in 2002, it was open only to 16 countries. And then again, the law was amended in 2005, expanded to all the countries. All countries, the Indian diaspora in any country can apply to become an overseas citizenship of India, to possess this overseas citizenship of India cardholder status, except Pakistan and Bangladesh. And in 2015, again the law was amended because before this overseas citizenship of India cardholder status, there was also another status which was given by the government of India, that is the person of Indian origin status, which started in the year 1999 itself. But then the government thought that this is very redundant and then we'll merge these two cards. And hence from 2015, there's only one cardholder status, that is the overseas citizenship of India cardholder status. The law says all the pre-existing person of Indian origin cardholder status would be converted as an overseas citizenship of India cardholder status, and anybody who applies new from 2015, they will be eligible to get only this overseas citizenship of India cardholder status. And whoever is having this particular card, they would be eligible for all the benefits that we have discussed. But however, they are not citizen of India. But however, they are eligible to become a citizen of India through the process of registration that we have already seen. So with this statement, with this information, come to the question. An overseas citizenship of India cardholder, although doesn't require visa to visit India, but they may require a prior permission or clearances to visit India in which of the following cases: research related activities. In 2021, certain new instructions has been issued by the Ministry of Home Affairs, which says that it is mandatory for them to get the permission of the government if they wanted to carry out any research activities in our country. Two, to carry out any activities related to missionary, journalist, tabligh is a branch of Muslim community, or mountaineering activities. So this is also true. So they have to take permission for doing any of these activities. An internship in any foreign diplomatic missions. If any overseas citizenship of India is coming and he wanted to do an internship in any foreign diplomatic mission, then also they have to take the permission. So this is also true. And if any overseas citizenship of India wanted to visit any area in India that is notified as protected, restricted or prohibited area. So for example, there is something which is called as inner line permit system, and there are other protected areas like the national parks and all those things. If they have to visit these areas, of course they have to take the permission from the government. So this is also true. So choose the correct answer from the codes given below. So the right answer is all the above. Okay. So with this we end the discussion. So I'm just again reiterating it. If you see the series of lectures, the last 10 classes including this particular class, if you see, we have covered the important topics like the fundamental rights, preamble, the directive principles of state policy, judiciary, both the high courts and the Supreme Court's important constitutional provisions. We have covered the legislature, parliament as well as the state legislature. We have covered the executives, the important officers like the president, the governor, and we also touched upon the constitutional bodies and some statutory bodies, and also certain extra constitutional bodies like Enforcement Directorate and the Central Bureau of Investigation. In addition to that, we have also touched upon the important schedules like Schedule 5, Schedule 6, we have touched upon Schedule 9, we have touched upon Schedule 10, and we also touched upon some of the other miscellaneous areas. So please watch these videos, and anyone who is preparing seriously for the Prelims 2023 examination, do watch these videos and benefit from these videos, and it can also help you to secure your place in Prelims 2023. Thank you very much. All the very best. God bless.